Yeah, so I got reference numbers. I don't have case numbers. It's default for failure to pay. And I called the other day.
The defendant's last name?
Staples.
First name?
Frank.
Date of birth?
12/18/1979.
Am I speaking with Frank?
Yes.
Frank, I'm going to put you on a quick hold, okay?
Thank you so much. Okay.
Frank, what was your date of birth?
12/18/1979.
And you're calling about a default?
Yeah, I believe there was multiple, and I called the other day. I went to Concord. I cleared one of them up, and they had mentioned, when I called, they mentioned one was like 150 and the other was like 700, and Concord didn't have anything, so I'm just trying to figure out what court these defaults and how many of them there are.
I see one out of Brentwood District for
Okay.
$765.
That makes sense. That's what I thought. Alright, so I'll have to head over there and clear that up. That's all I needed to know. That is 429-2021 CR3652.
No, that is going to be 435-2021 CR240.
435-2021 CR
240.
240. Huh. Okay. Yeah, they told me a different one at Concord. 240. All right. Yeah, I think I know which one that is. All right. Thank you so much.
You're welcome. You have one for us today?
You as well. Thank you.
Thank you. Bye-bye.
Bye-bye. All right. So that was a call about some defaults. You saw the previous videos. I cleared one up. That was for an unregistered vehicle. I don't have video of that. And I didn't file a motion to dismiss or anything. I honestly wish I did record it because it was pretty good regardless of the guilty verdict. But they took it under advisement and then they sent me a guilty thing, and then they defaulted me for not paying the fine. And so I had to clear that and ask for a hearing. And in New Hampshire, we do $150 a day in jail to take care of a fine. So that's what I'm going to be doing. And I also have another default for, I just looked it up, it's the COVID carols. I'll try to remember to link it in the description here. But that was my second picketing arrest for second disorderly conduct and second picketing ticket. And there's a $765 thing. I was going to appeal it, and the judge didn't give a written decision, and so I filed this for a written decision, and she refused to give me a written decision, which is necessary for appeals purposes. And so this is my motion to request written decision for guilty verdict in case number 435-2021240. And I, Frank Staples, defendant, hereby file this motion to formally request that Your Honor provide a written decision for the guilty verdict rendered on 12/23/2021 in the aforementioned case. This request is made in accordance with the following rules, laws, facts, legal analysis, legal arguments, and supporting case law. The defendant, during sentencing hearing on 12/23/21, informed Your Honor of his intention to appeal the guilty finding and expressed his need for a written decision to file his appeal in brief with the Supreme Court of New Hampshire. Regrettably, the defendant's attempts to file the appeal were hindered as he was unable to meet the Supreme Court filing requirements due to Your Honor's failure to comply with Rule 27A and New Hampshire RSA 625-9 and both state and federal due process protections. Consequently, Your Honor's negligence in providing a written decision, has severely prejudiced the defendant, denying him the ability to fully appeal his case as mandated by New Hampshire Constitution, Article 14. Without a written decision, the defendant is unable to comprehend the precise nature of the guilty verdict, thereby impeding his ability to articulate arguments for the appeal or file a comprehensive brief in this matter. The defendant's appeal was dismissed by the New Hampshire Supreme Court on December 22nd, 2022, solely due to his failure to submit a brief resulting from the absence of a written decision to contest against. In response, the defendant filed a motion on 12/27/2022 seeking the legally required and obligatory written decision from Your Honor as per the aforementioned rules, statutes, and constitutional protections. However, on January 17th, Your Honor deemed this request for a written decision as moot without providing an explanation. The defendant firmly asserts that this issue is not moot and demands a written decision as compelled by the aforementioned facts and arguments. Moreover, Your Honorable Judge Hall did file written orders of cases 43201 CR 46, 435 2021 CR 239. These two orders technically aren't full written decisions, but because they were not guilty verdicts, they are moot. Although there is not any kind of decision or written order for 4325240. So basically what I'm saying is I had these not guilty verdicts and she provided a written decision for those, but then the guilty verdict she doesn't provide a written decision for. So it's kind of crazy. This discrepancy can only be rectified with a written decision on the merits with findings of facts and rulings of law. A dispositioning and sentencing form are merely official filings of the verdict, and accompanied sentencing is not a substitute for a written decision on the merits. They are mutually exclusive and independent requirements. In consideration of the specific requirements for a decision regarding a Class B misdemeanor in New Hampshire, they will vary depending on the particular offense and case circumstances. Nevertheless, the following elements are generally taken into account. The nature of the offense must be classified as a Class B misdemeanor. Presented evidence. The prosecution must present sufficient evidence to prove the defendant's guilt beyond a reasonable doubt. Defendant's criminal history, mitigating and aggravating circumstances, and applicable sentencing guidelines. Ultimately, the decision regarding a Class B misdemeanor in New Hampshire rests with the judge, who evaluates those factors in light of the specific case details. Regarding the question of whether the decision should be written, it is crucial to acknowledge a written decision is essential for Class B misdemeanor cases in New Hampshire. In criminal cases, judges typically issue a written decision or order that includes findings of facts, legal analysis, and the imposed sentence or other disposition. A written decision promotes transparency, accountability, and provides a clear record of the judge's reasoning. Furthermore, it ensures that all parties involved have a comprehensive understanding of the decision's basis and facilitates potential review by higher courts. To support this request, the following legal authorities are relevant. New Hampshire Rule of Criminal Procedure Rule 27A. This rule mandates that the court must state in writing its findings of fact, conclusions of law, and reasons for the decision in all criminal cases, including those involving Class B misdemeanors. New Hampshire Revised Statute 625:9. This statute requires that the court shall state its reasons for selecting the particular sentence imposed in misdemeanor cases. It supports the necessity of a written decision to ensure clarity and transparency in the court's reasoning. Article 15 of the New Hampshire Constitution. This constitutional provision guarantees due process of law and prohibits the deprivation of liberty without it. A written decision is crucial to prevent the deprivation of liberty without a clear and reasoned explanation. Sixth Amendment guarantees a right to a fair trial, including the right to a written decision. Supreme Court has recognized the necessity of a written decision to enable meaningful appeals and ensure transparency in the criminal justice system. Case law. Numerous cases from New Hampshire and other jurisdictions support the requirement of a written decision in criminal cases. For instance, State v. Maxfield emphasizes that a trial court must provide a specific explanation for its decision to enable appellate review. The whole point of this. Similarly, in the United States v. Dominguez Benitez, highlights the importance of a reasoned written decision to protect a defendant's Sixth Amendment rights. In light of the aforementioned legal authorities, it is evident that a written decision is indispensable in Class B misdemeanor cases in New Hampshire to safeguard due process, transparency, and accountability. Therefore, Mr. Staples urgently requests written decision in this matter. It is, as it is long overdue and essential for his right to appeal. For those reasons, the defendant respectfully requests that Your Honor promptly issue a written decision in accordance with the rules, statutes, constitutional protections outlined above. Your cooperation in rectifying this matter and ensuring justice is served will be greatly appreciated. Respectfully submitted as not moot. So, she didn't give me a written decision, and this is a theme in a couple other cases that I have as well. But now that they're basically gonna have to jail me for $150 a day for this $765, which is what, 2, 4, 6, 7. It's like a week in jail, right? I can bring this up again about my appeal rights being hindered by her refusing to provide a written decision. And so hopefully I can get the written decision. I might prepare a habeas corpus petition prior to this hearing that I have. Boom, lighting off fireworks. So yeah, I will probably do something like that, and I'll have someone file it on my behalf once or I'll right before I get taken away. I will submit it to the court, right? Habeas corpus petition, and then they'll bring me to jail, or maybe they'll give me bail. I don't know what they're gonna do, but we're gonna find out. fuck around, find out. So I'll keep you guys updated with all this stuff. Thank you so much. All right, so I just got some discovery from the towing incident of my vehicle, and it says something interesting in there. I've requested a hearing about the reasonableness of the tow, and this is going to, I have a hard time believing that I'm not going to get my money back for this. The guy lied and said it was a there was a felonious something. There was something with a felony involved, and there was no felony and there was no arrest. And so that's why he called them to tow over some felony or arrest. And I'm following up right now with the Department of Safety to see what's going on with this hearing that I requested.
Thank you for calling the New Hampshire Department of Safety.
I think it's 4.
This is an emergency.
Wait while I transfer your call.
Department Safety, Bureau of Hearing.
Hi, how you doing? I called a while ago, and then I sent an email about requesting a hearing about the reasonableness of a tow, and I'm just trying to figure out what the status is on this.
Okay, and what's your name?
Frank Staples.
Okay. Hang on. And your date of birth, Frank?
12/18/1979.
Thank you. So let's see if we scan this to your file yet. No. Okay, nothing has been scheduled yet. I think on this one was a weird one where I don't think we are the jurisdiction.
Yeah, there seems to be some confusion on like all sides. And in the email, they said that I need to contact the chief of police, and I CC'd him on that email, so he knows. And you know, it also says that I would receive a hearing at a court of competent jurisdiction, and the chief of police isn't a court of competent jurisdiction. You know.
Yeah, I'm thinking it might be the district court. It might not be anything.
They told me it was Department of Safety, and they like did a bunch of research, put me on hold for a while, and they didn't know at first, and then they came back and said that to call you guys, Department of Safety, to schedule a hearing. And you guys are the only ones with a hearing option. And they were aware of the excessive fee hearing process, but they were not aware of this unreasonable tow process, which I would assume it would be you guys, because like I said, the chief can't conduct hearings.
Yes, I don't think the hearing wouldn't be held here, and it wouldn't be held at the police department. It's not. I think our administrator still has it, and he plans on getting back to you. I just think he hasn't yet.
Okay.
Because I did speak with him, and we just didn't know. We know that it's not us. We just don't know where exactly to direct you further.
Yeah, because I mean, I really need my money back, the $245, and I got the discovery today, and it says in the arrest or the towing information, right? It says, one second, towed for felonious use / arrest. Felonious use / arrest. I was not arrested, and I was not charged with any felony. And he let me drive. I was allowed to drive away. The car was dropped 10 miles away, but the cop was like, we're not leaving until it's on the back of the tow truck. and we'll fight it in court. He was completely unreasonable. You know, this really put me in a difficult position. You know, took half my paycheck from work.
No, absolutely. Yeah, so I know that we have your information and we have that, all the emails that you sent in.
Okay.
So I would just, wait to hear back from us.
All right, I'll keep my eye out. Thank you so much.
You're welcome.
All right, have a good one.
You too, bye-bye.
All right, bye. I mean, this is crazy that the state doesn't even know the law or how to administer it. The district court didn't know what was going on. Department of Safety don't know what's going on. The chief of police don't know what's going on. It's pretty mind-blowing. But I think this situation here is, the tip of the iceberg on a broader issue on how they're, unreasonably towing people, probably a lot more than we realize, and people aren't even given notice that they have a right to a hearing to dispute the reasonableness of the tow. And we all know that they use the tow to get around the Fourth Amendment, and because part of the tow process and procedure is the officer has to follow the vehicle, and then do an inventory search whenever it gets to wherever it's being impounded. And so he didn't do any of those things. His, goal and purpose was just to make it as difficult as possible for me. And then maybe I wouldn't even be able to pay for the tow, and the tow company just comes and takes it on his request, and then they hold on to it because I can't pay, and then they end up keeping my vehicle, right? Just because this guy wanted to have my vehicle towed outside of the statute, which carries a maximum penalty for what he charged me with. Maximum penalty, $100 fine. There's nothing saying you could tow the vehicle. So we'll see where this goes. I think this hearing should be very interesting, and I'm looking forward to this hearing.